Our expert said you have a great case. He said you have a fantastic case. Now, after your lawsuit was started, the defense reaches out to us after they've reviewed all your records, after they've done your testimony, after they've had an expert review it, and they come back to me and say, Gerry, our expert, the defense expert, says you have a terrible case. You don't have a case. How is it possible that two well-qualified experts looking at the same sets of records can come to two opposing conclusions? Would you like to know the answer? Come join me for this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you believe that your doctor was careless and caused you significant harm and injury. Now, as part of the investigation process to see whether or not you have a valid case, we are obligated to go ahead and obtain all of your medical records. Now, I will go ahead and go through all of your medical records to familiarize myself with every detail, every page of your records, and then I will hire the best medical expert I can find to evaluate and review those records. Now, what's the expert looking for? The expert is looking for three things, really. Number one, did the doctor, or the doctors, or hospital staff, did they depart from the standard of care? If they did those departures from the standard of care cause you harm and injury? Now, if they did, then the other question becomes, how significant are your injuries? Are they permanent? Are they disabling? Are they life-altering? If the expert finds that the answers are yes, yes, and yes, yes, the doctor was careless, yes, his carelessness was a cause of your injury, and yes, your injuries are significant and permanent, now we have a valid basis to proceed forward. So we go ahead and we draft the papers necessary to start your lawsuit. The lawsuit gets started. We prepare a document called the Bill of Particulars, which itemizes and details exactly why we believe that the doctor and the hospital staff were careless and caused you significant harm and injury. And now we itemize and we detail all of the injuries that you suffered. The defense now has an opportunity to go ahead and obtain all of your records, to do the same type of investigation that we did, just many months later. So we are required to give them authorizations, permission slips, to go ahead and get records from your doctors and hospitals directly. We are also required to give them copies of whatever records we obtained. And now they will go ahead and have those records reviewed by various medical experts. So how is it possible? And this happens in almost every single case. The defense comes back and says, listen, we've had an expert review your client's records, and they don't feel that there's a case here. They don't see that there's any liability. They don't see that anyone did anything wrong. And in addition, we think your client caused her own injuries. And on top of that, we don't think your client's injuries are really that bad. Those are the typical defenses that they raise in these medical malpractice cases, which happens to be very frustrating, especially when we tell the client what these defenses are. Okay, so let's get back to the question that I raised. How is it possible that two well-qualified medical experts, looking at the same sets of facts, come to two totally opposite and opposing opinions? I'll tell you how. Each expert has a different thought or a different opinion as to why they believe they are right. Our expert has come to the conclusion that yes, the doctor violated from the basic standards of care. The defense expert says no, there was no departure from the standard of care. This doctor did everything right, everything he should have done. Who's right? Who's wrong? Well, you know what? That's ultimately for a jury to decide. If two medical experts reviewing the same sets of facts reach totally opposite conclusions, that creates what's called a question of fact. Who is right and who is wrong? You see, when we go to trial, we are required to show that we, the injured patient, the plaintiff, the person bringing the lawsuit, is ever so slightly more likely right than wrong, than what we are claiming is true. We don't have to show with 100% certainty that we are more right than they are. We don't have to be 100% certain that the doctor violated the standard of care. We only have to show that we are only slightly, little bit more than 50%, more likely right than wrong than what we are claiming is true. Each doctor who reviews these cases may have a different viewpoint. They may have a different bias. They may have a different experience level. They may have the same scenario in their own practice. In some instances, the expert who is retained by one side or the other may not have sufficient expertise or knowledge about this particular incident or this particular set of facts and this type of treatment. Now, if there's a surgeon that's involved, and now they get someone who doesn't have an expertise in this particular type of surgery, that may affect this expert's opinion as to whether or not there's wrongdoing. There are many instances where we actually need to get the same type of expert, the same type of physician to review the records as the one who treated you. Could we go ahead and get a general internist to review a surgical case? The answer is yes, but that internist would then have to explain to a court ultimately how it is that they are familiar with the standard of care of a surgeon, how they are familiar with what a surgeon does and what is appropriate in the course of surgery if they are not a surgeon. In order to avoid that problem, the best thing to do is to obtain the same type of expert as the one who treated you. This way, we rarely have an issue about the qualifications and the expertise and the experience of the doctor who reviewed the records, who confirmed that you have a basis for a case. So why do I share this quick information with you? I share it with you just to open your eyes, to help you realize what really happens in these medical malpractice cases in New York. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.